Welcome, KSLU students, to today's strict, exam-oriented explainer, right? Let's dive directly into this. Today, we're dissecting the exact statutory differences between an agent and a servant under the Indian Contract Act of 1872. Listen, if you're aiming for distinction in your university examinations, you simply cannot afford to confuse these two concepts. We are looking strictly at the black letter of the law today, so pay close attention, take out your notebooks, and prepare to master this absolutely vital area of commercial law.
Write down these 6 precise headings immediately. 1. Agency under Contract Act. 2. Agent versus servant distinction. 3. Landmark case control test. 4. Principal and third parties. 5. Agent fraud and ratification. And 6. Final KSLU exam strategy. This is your infallible structural blueprint for scoring full marks on your 16-mark university essay. Do not deviate from this sequence.
We begin with our first major heading, Agency under Contract Act. We are laying the foundational legal premise here.
I'm going to read this definition verbatim first. Agent represents the principal in dealings with third parties. Servant works under the control of the employer. Only an agent creates contractual relations. Now listen to me carefully. I expect you to use this exact phrasing as your opening paragraph. It will immediately impress the KSLU evaluator. The crux here is that the agent is a bridge. The servant, however, is merely a tool performing tasks under strict supervision.
Let's move directly into Section 2, Agent versus Servant distinction. This is the absolute heart of the syllabus topic.
Take down this comparative analysis row by row. Basis 1 is nature of work. The agent represents the principal in dealings. The servant performs work under the employer. Basis 2, authority. The agent can create legal relations. The servant cannot bind the employer. Basis 3 is control. The agent works with some independence. The servant works under direct control. Basis 4, remuneration. The agent receives a commission or fees. The servant receives a salary or wages. Basis 5, liability. The principal is bound by the acts of the agent, but the employer is liable under service law for the servant. And finally, Basis 6, scope. The agent's scope is wider and includes contracts. The servant's scope is limited strictly to the execution of work. Reproducing this exact 6-point tabular format on page 1 of your answer script is mandatory for distinction marks. Evaluators actively look for this structured, comparative logic. The key point here is strict, and you need to memorize it. An agent creates contractual liability, whereas a servant does not create contractual liability. It's a binary outcome. This distillation is the absolute crux of the distinction. In your exam, you literally must double underline this concept. An agent steps into the shoes of the principal to bind him to a third party. A servant has absolutely no such legal power.
Section 3, Landmark Case Control Test. Stop writing for a second and focus.
Note this vital case law down. Lakshminarayan, Gopal and Son Limited versus Hyderabad Government. Draw a physical box around this case name on your paper to catch the evaluator's eye. In KSLU exams, quoting bare acts without jurisprudence will cap your marks at average. Let's perform a strict legal autopsy here. First, the facts. A company acted as agents for another entity earning a commission, but they operated with considerable independence in how they executed their trade. The tax authorities tried to classify them as servants to levy a specific tax. Second, the ratio decidendi, or the court's reasoning. The Supreme Court held that the fundamental difference lies in the degree of control and authority. A master tells a servant what to do and exactly how to do it. A principal tells an agent what to do, but the agent retains discretion on how to actually execute it. Third, the relevance. This brilliantly illustrates the control test. You must cite this case whenever you're asked to differentiate between an agent and a servant based on independence and supervision.
Let's move to heading 4, Principal and Third Parties. We're transitioning into the second half of our 16-mark blueprint here.
Note this heading precisely. Number 1, Acts within Authority, Section 226. Write this down and clearly cite Section 226 in the left margin of your exam paper. Section numbers are the backbone of your legal argument.
Let's read the specific effects under Section 226. First, the principal is bound by acts of the agent. Second, it has the same legal effect as if the principal himself acted. And third, the third party can sue the principal or be sued by the principal. Think of the agent as a mere legal conduit, like a transparent pipe. The actions flow straight through the agent and land directly on the principal. If the agent signs the contract within their authority, it is legally identical to the principal picking up the pen and signing it themselves.
Now, what if the agent actually exceeds their authority? Compare these two scenarios under Sections 227 and 228. Separable acts, principal bound only to the extent of authority, versus inseparable acts, principal not bound at all. Explicitly compare these two on your paper. If an agent is authorized to buy 100 bales of cotton but buys 100 bales of cotton and 10 of silk, well, if the transactions can be separated, the principal pays for the cotton. That's separable. But if the agent buys a mixed, totally inseparable lot, the principal can repudiate the entire transaction. I'm warning you, KISLU problem-based questions frequently test this exact boundary.
We now announce the next subheading, Undisclosed Principal, covering Sections 231 to 232.
This deals with situations where the principal's identity is completely hidden from the third party at the time of the contract. So, what's the remedy? The third party may sue the agent or sue the principal once discovered. Dissect this carefully. Because the third party thought they were dealing only with the agent, the law gives them a choice. Once the true hidden principal is revealed, the third party has the statutory right to elect exactly who to hold liable.
I'm going to pause the lecture right here to ask you a strict probing question. What happens if a person falsely represents himself as an agent under Section 235? Think about this for a second. If someone lies about having authority and causes a third party to enter a contract, where does the penalty actually fall?
Well, here is the definitive answer. Number 5, pretended agent, Section 235. He is personally liable. I command the class to write this down and heavily underline personally liable in your notes. The law does not protect imposters. If you pretend to be an agent, you step right into the line of fire yourself.
Move down to point 6, personal liability of agent under Section 230. Generally, an agent is not personally bound by the contracts they make, right? However, Section 230 gives us critical exceptions. An agent is personally liable when the contract expressly states so, the principal is foreign or undisclosed, or a trade custom exists. Dictate these 3 specific exceptions to yourself meticulously. If a KSLU question asks for exceptions to agency immunity, missing even one of these 3 points will cost you marks.
Now, Section 5, Agent Fraud and Ratification. What happens when things go legally wrong? Note this absolutely critical case law. Lloyd versus Grace, Smith, and Co. This is your second mandatory case law deep dive.
Point 3, principal bound by agent's misrepresentation or fraud under Section 238. If committed within authority, the principal is liable. Now let's strictly analyze Lloyd versus Grace, Smith, and Co. The facts. A widow went to a firm of solicitors to sell her cottages. The managing clerk of the firm, acting as an agent, fraudulently induced her to sign documents that transferred the property to himself, and he then absconded with the money. The ratio decidendi. The House of Lords held the principal firm fully liable. Why? Because the clerk was acting within the scope of his apparent authority when he asked a client to sign property transfer documents. The relevance? This case proves that a principal is liable for the fraud of his agent committed in the course of employment, even if the fraud was committed solely for the agent's own benefit. Explicitly box this case on your exam paper to grab the evaluator's attention when discussing Section 238.
We now move to the final statutory provision block. Point 7, Ratification, covering Sections 196 through 200. Note the mechanics of this concept on the screen. The principal may approve unauthorized acts. This makes them binding from the beginning. This is the retrospective legal magic of ratification. If an agent acts entirely without authority, the principal can later step in and say, I accept this. Once ratified, the law treats the contract as if the agent had full authority from the very first second the contract was made. It cures the defect entirely.
We conclude this lecture with Section 6, our final KSLU exam strategy. To summarize perfectly, remember that the entire distinction between an agent and a servant rests on 2 pillars, authority and representation. Master the statutory boundaries, memorize the control test from the Lakshminarayan case, and deeply understand the vicarious liability demonstrated in Lloyd versus Grace. If you structure your answer with the headings and tables we dissected today, distinction is practically guaranteed. I'll leave you with this final provocative thought to ensure you synthesize the material. If an agent's simple signature can bind a billionaire principal across the globe, how much of modern international commerce relies entirely on this invisible, yet unbreakable, legal thread of agency? Study hard, and I will see you in the next explainer.